Welcome. This video explains the process for a request for review under Section 26 of the Alberta Human Rights Act. We'll walk you step by step through what a request for review is, how the process works for both parties, and what to expect next. For more information on your rights, we suggest you consult a lawyer. If the director dismisses a complaint, the parties receive a dismissal decision. Under Section 26 of the Act, the person who made the complaint has the right to request that the chief reviews that dismissal. This process allows both the complainant and the respondent to provide written positions to the chief of the commission and tribunals. A request for review is a written process where the chief reviews whether the director's decision to dismiss the complaint was correct. It is not a hearing, but a review of the existing decision and the written record. Timing is critical for both sides. The complainant must file their request for review within 30 days of the date the dismissal decision was emailed. This deadline cannot be extended for any reason. Once the request for review is filed, the respondent has 30 days to file their response. All deadlines are strictly enforced at 4:30 p.m. on the final day of the deadline. The chief makes a decision based only on written submissions and documents. There is no in-person hearing or oral argument. This means your written words are your only opportunity to explain your position to the chief. The chief reviews three main components: the record of information the director used to make the original decision, the complainant's reasons for the request for review, and the respondent's response to those reasons. The director automatically provides the tribunal office with the documents used to make the original decision. Neither party needs to resend these materials. Your submissions should focus on why the director's decision was either correct or incorrect based on those facts. Submissions from either party must include clear written reasons. If you are requesting the review, explain why the decision should be changed. If you are responding, explain why the decision should stay the same. You may include information that is directly relevant to these arguments. While you are not required to consult a lawyer, the arguments you make must address the legal issues of the case. The review is limited to existing complaint. You cannot add new allegations. Submissions are limited to 30 pages total. Audio or video recordings will not be accepted. In certain rare circumstances, you might be able to ask for written approval from the tribunal office prior to submitting audio or video recordings. Each party has a strict 30-page limit for their submission, including all attachments. If a submission exceeds 30 pages, only the first 30 pages will be provided to the chief. All decisions issued by the tribunal are posted on CanLII. Making decisions public fosters transparency and assists the public in understanding the law. In exceptional circumstances, where highly personal and sensitive information is required to support the decision's analysis and reasoning, the tribunal may decide to anonymize the decision. If a party wishes to argue that their name should be anonymized in the chief's decision, this request must be made clearly within the request for review or response submissions. The chief will make a ruling on anonymization as part of the final request for review decision. Please note that any requests for anonymization made after a decision has been issued will not be considered. The process follows a set order. Once the complainant files their request for review, the tribunal registrar serves a copy on the respondent. The respondent then has 30 days to provide their written response. After the respondent files, their submission is shared with the complainant. In most cases, the respondent's response is the final submission accepted before all materials are sent to the chief for a decision. The chief can make one of two decisions. They may uphold the dismissal, which means the complaint is complete and no further action will be taken. Or they may overturn the dismissal and refer the complaint to a tribunal for a full hearing. If the complaint is referred to the tribunal for a hearing, the parties will be asked to participate in tribunal dispute resolution. Many cases resolve at TDR, and the ones that do not are quickly set for a pre-hearing conference to schedule dates for the oral hearing. If there is a hearing, the parties will prepare their cases, make written submissions, and schedule witnesses to provide evidence in support of their position. All communication and service are done primarily by email. Ensure the tribunal office has your current contact information. For more details, you can consult the tribunal's practice direction on request for review under Section 26 found on our website. Thanks for watching. Please visit our website for more information on the tribunal's process.